Chapter 27. Injunctions to protect patents, copyrights and literary property, trademarks and trade names, exclusive franchises. Section 565. Patents, in general. The jurisdiction of equity to restrain infringements of patents is well settled. From the nature of the right and of the wrong, the violation being a continuous act, the legal remedy is necessarily inadequate. The ordinary form of relief is an accounting of profits and an injunction in equity. Indeed, the action at law is seldom resorted to, except for the purpose of establishing the validity of the patent or copyright by the verdict of a jury when it is really contested. Under the Constitution of the United States, the cognizance of suits for the infringement of these rights belongs exclusively to the federal courts. As in all cases coming within the jurisdiction of law or equity, the complainant must show a right in himself and a violation thereof by defendant. To establish his right, he must prove two distinct elements, viz. 1. That he is the legal or equitable owner of a patent right, and 2. That the patent is valid. The violation of the right is the infringement of the patent. Section 566. Requisites of bill. It is sometimes stated that a bill for a permanent injunction against the infringement of a patent must show that the right has been established at law or that it has long been acquiesced in by the public, but the better rule seems to be that these allegations are not essential. A court of equity will try the validity of the patent without the intervention of a jury. The reason given for the exercise of this jurisdiction is that a verdict of a jury in a case so intricate as one involving the validity of a patent is generally far from satisfactory. Section 567. Magnitude of injury is immaterial. The right to a permanent injunction does not depend in any degree upon the magnitude of the injury which the plaintiff has suffered. He has an exclusive right which he is entitled to have protected. A mere failure on the plaintiff's part to use the patent and a refusal to allow others to use it on reasonable terms, are not sufficient to warrant refusal of injunctive relief. Section 568. Incidental relief, accounting, damages. It is a settled principle of equity that where jurisdiction is taken for one purpose it will be retained in order to award full relief. Accordingly, equity, after granting a permanent injunction against the infringement of a patent, will retain the bill to decree an account of profits and sometimes to award damages. The distinction between profits in equity and damages must be carefully noted. Profits are the gains or savings made by the wrongdoer by the invasion of the complainant's property right in his patent. They are the direct pecuniary benefits received, and are capable of definite measurement. If an infringer of a patent has realized no profit from the use of the invention, he cannot be called upon to respond for profits. Originally, damages could not be awarded in an equitable action to restrain infringement, but this rule has been changed by statute. Gains and profits are still the proper measure of damages in equity suits, except in cases where the injury sustained by the infringement is plainly greater than the aggregate of what was made by the respondent, in which event the provision is, that the complainant shall be entitled to recover, in addition to the profits to be accounted for by the respondent, the damages he has sustained thereby. A bill in equity for a naked account of profits and damages against an infringer of a patent, cannot be sustained. Such relief is ordinarily incidental to some other equity, the right to enforce which secures to the patentee his standing in court. Section 569. Retention of bill after failure of right to injunctive relief. Where a bill in equity is brought upon a patent, and during the pendency of the suit the right to an injunction fails by reason of the expiration of the patent, the suit is not determined, but the court will proceed to administer the other relief sought. It is sometimes held that the true test of jurisdiction is whether the bill is filed in season to enable complainant, under the practice and rules of court, to move for and obtain an injunction before the expiration of the patent. Where the bill is filed at so late a date that not even a preliminary injunction can be obtained, the court may dismiss the suit. Where the right to injunctive relief fails by reason of the death of the defendant after the filing of the bill but before the decree, the court may retain the case to award an account of profits against the executors. Section 570. Grounds for denial of relief. Occasionally, when there is an established license fee for the use of a patent, Courts of equity refuse relief upon the ground that there is an adequate remedy at law. The courts argue that in such cases the real injury to the plaintiff does not consist in using the invention, but in not paying for it. It is to his interest that his device be widely adopted, and his profit comes from the sums paid for licenses. Frequently there is connected with these cases an element of hardship which appeals to the courts. The patented article may be a small part of a machine used by a large manufacturing establishment, and the effect of an injunction may be to close the concern and cause great loss. Under these circumstances, the courts are often led to deny injunctive relief. It would seem that some such case as this must arise in order to warrant the refusal of final relief on the ground of hardship. Section 571. Abandonment of infringement. When it appears that prior to the commencement of suit defendant had wholly ceased to infringe and was not threatening and did not intend to infringe further, but had in good faith entirely and finally abandoned the manufacture and sale of the article, an injunction may be denied, but in such case, it is held, the defendant must set up in his answer that infringement is not further intended. Section 572. Lackeys. Unreasonable delay and the deceitful acts or silence of a patentee which induce an infringer to incur expenses or to become liable to losses and damages which he would not otherwise have suffered, may sometimes justly induce a court of equity to stay his suit for an infringement or for an accounting before the time fixed by the analogous statute of limitations has expired. But delay, unaccompanied by such deceitful acts or silence of the patentee, and by such facts and circumstances as practically amount to an equitable estoppel, will warrant no such action. Section 573. Preliminary injunctions. The principles upon which preliminary injunctions issue are well settled. The purpose of the interlocutory writ is not to conclude the question of right but to protect against material injury pending the litigation. In patent cases, to warrant the writ, not only must the infringement be without reasonable doubt, but the rights of the patentee must be clear. Failing prior adjudication in favor of the validity of the patent, there must be shown such continued public acquiescence in the exclusive right asserted as raises a presumption of validity, a presumption not arising from the letters patent, unless accompanied by public acquiescence, where the validity of a patent has been sustained by prior adjudication. The only question open on motion for a preliminary injunction is the question of infringement, the consideration of other defenses being postponed until final hearing. This rule is subject to exceptions, however, where the new evidence is of such a character that if it had been introduced in the former case it probably would have led to a different conclusion. The equity court may go behind the record and consider all the facts. The burden is on the defendant to establish this, and every reasonable doubt must be resolved against him. Again, where the prior litigation was the result of collusion, the judgment is not conclusive. If the right of the plaintiff or the infringement by the defendant is doubtful, preliminary relief will, in general, be denied. In some cases, however, a temporary injunction has been granted, although the right has been doubtful, upon the ground that the granting of it would injure defendant less than the withholding it would injure complainant. This same principle prevents relief in some instances where the right is not doubtful, when the injury to the defendant by a preliminary injunction will far outweigh any advantage to the complainant therefrom. In such cases the defendant is generally compelled to give a bond to keep an account of sales. Section 574. Copyrights. The principles governing the issuance of injunctions against the infringements of copyrights are similar to those relating to patents. A copyright gives an exclusive right which the owner is entitled to have protected by injunction. It is not necessary that any actual damage be shown. Where the infringement is otherwise established, the intention is immaterial. Therefore, an allegation of the defendants that they had no intention to infringe is not a defense. Where the right to an injunction is established, an account of profits may be awarded as incidental thereto. An author, however, who has pirated a large part of his work from others is not entitled to have his copyright protected. Section 575. Same preliminary injunctions. In order that a preliminary injunction may issue to restrain the infringement of a copyright, both plaintiff's right and defendant's infringement must be clear. It is proper for the court to consider the harm that would be done to the complainant by refusing such an order, in comparison with the damage that might be sustained by the defendant in consequence of granting the same. The ability of the defendant to respond to any damages that may be assessed on final hearing is also an important element, and in these respects there is no difference in the rule governing cases arising under patent and copyright laws and other equitable proceedings. Section 576. Analogous rights, literary property. In analogy to the protection of copyrights, a jurisdiction has become well established by modern decisions to restrain the invasion or piracy of literary property in the product of intellectual labor, which still remains in the form of manuscript, or which, if printed, has not been published, and over which, as a consequence, no statutory copyright has been obtained, and to restrain the invasion of a similar right which an artist has in his pictures and other original works of his creative art. This jurisdiction belongs to the state courts. It will be exercised to restrain the unauthorized publication of unpublished manuscript or printed matter in violation of the rights of the person entitled thereto. The unauthorized publication, performance, representation on the stage, or other similar uses of dramatic compositions which have not been published by the author or proprietor, the unauthorized publication, delivery, or other like use of lectures which have been delivered by the author, but not otherwise published, the unauthorized making, sale, or exhibition of copies of paintings, engravings, and other works of art, even though the originals may have been publicly exhibited, and the unauthorized publication of private letters, whether on literary topics, or on matters of private business, friendship, or family. Section 577. Trademarks, somewhat akin to the protection of patent and copyrights, is that which courts of equity give, by means of the injunction, to the peculiar species of right arising from the adoption and use of trademarks. Although some judicial opinions and some recent statutes speak of property in trademarks, or call the right to their exclusive use a kind of property, yet in strictness the remedy does not depend upon any true property acquired in these symbols and names, but upon the broad principle that a court of equity will not permit fraud to be practiced upon the public nor upon private individuals. It is well settled by modern decisions, that when a trademark has been duly acquired by a manufacturer or dealer, an injunction will be granted at his suit to restrain other persons from using it upon their goods, or from using such imitations of it as will tend to mislead and deceive the public. For a discussion of the numerous questions concerning the nature and validity of trademarks, who may acquire them, how they may be acquired, what imitations are wrongful, and the like, the reader must be referred to the special treatises upon the subject. Section 578. Unfair competition. It is not essential that a party have a technical trademark in order to be entitled to the protection of equity. When one imitates the goods, form of packages, labels, or name of his business competitor in such a way as to deceive the public, he may be enjoined at the suit of such competitor. The ground for this jurisdiction is the general one of the prevention of fraud on the public. We have already seen that this is one of the reasons given for the protection of trademarks, but in those cases there is the added element of the protection of an exclusive right. In the class of cases we are now considering, there is no exclusive right in the sense in which we speak of such a right in regard to trademarks. Courts in speaking of these cases generally classify them as instances of unfair competition. An actual fraudulent intention, although generally present, is not essential. The injury is the same whatever the motive may be. The wrong consists in deceiving the public to the injury of the plaintiff. If the public is deceived and the plaintiff is injured as a result, the defendant's good intentions cannot excuse the wrong. Section 579. Same continued. Unfair competition takes many forms. It may consist in the imitation of the color, form or style of the boxes, bottles or packages used by a competitor. Again, it may consist in the imitation of a label in common use. It may be the designation of an article by a name similar to that used by a competitor, although the name is not such as can be a technical trademark. It may be such a close imitation of the article itself as to color, size, or lettering as to deceive purchasers. In all these cases the question is whether the similarity is such as to cause confusion and to deceive the public into taking other goods than those of plaintiff. If this confusion and deception will result, equity will generally grant an injunction. Section 580. Trade names. Where one adopts a trade name so similar to that of another that confusion is sure to result and the public will thereby be deceived, an injunction will issue at the suit of the party who first adopted the name. It is beyond the scope of this treatise to discuss in detail what may be appropriated as a trade name. It is sufficient to state that such a name must not so closely resemble another's name as to be calculated to deceive. The name of a person may become so associated with his goods that one of the same name, coming into the business later, will not be allowed to use his own name without distinguishing his wares, and if he attempts to do so, he will be restrained by a court of equity. As in all cases of unfair competition, an actual fraudulent intent is unnecessary. Section 581. Corporate names. The right of one corporation or an individual to enjoin another from using a similar corporate name depends largely upon the form of the statutes. When there are no statute provisions as to the choice of names, and parties organize a corporation under general laws, they choose a name at their peril. If they take one so like that of an existing corporation as to be misleading, and calculated to deceive the public, they may be enjoined, if there is no language in the statute to the contrary. On the other hand, where the language of the statute makes the certificate of the state official conclusive, and perhaps where the defendant is organized under special act, there is no redress. In some instances injunctions have been granted at the suit of foreign corporations, restraining domestic corporations from using similar names. It would seem that such relief should be freely granted at the suit of a domestic against a foreign corporation doing business within the state. Section 582. Application of clean hands maxim. It is a well-established maxim that he who comes into equity must come with clean hands. This applies strongly to parties seeking relief against the infringement of trademarks and against unfair competition. One seeking relief against the frauds of others must himself be free from fraud. An exclusive privilege for deceiving the public is assuredly not one that a court of equity can be required to aid or sanction. Accordingly, it is held that it is essential that the plaintiff should not in his trademark, or in his advertisements and business, be himself guilty of any false or misleading representation, that if the plaintiff makes any material false statement in connection with the property which he seeks to protect, he loses his right to claim the assistance of a court of equity, that where any symbol or label claimed as a trademark is so constructed or worded as to make or contain a distinct assertion which is false, no property can be claimed on it, or, in other words, the right to the exclusive use of it cannot be maintained. Thus, relief has been denied to parties seeking an injunction against the use of the words fig syrup when it has appeared that figs constituted a very small if any part of plaintiff's compound bearing that name. Other instances of the application of the principle will be found in the notes. Section 583. Exclusive franchises. An injunction is the appropriate remedy to protect a party in the enjoyment of an exclusive franchise against continuous encroachments. Such continuous encroachments constitute a private nuisance which courts of equity will abate by injunction. The jurisdiction rests on the firm and satisfactory ground of its necessity to avoid a ruinous multiplicity of suits, and to give adequate protection to the plaintiff's property in his franchise. To be entitled to relief, a plaintiff need show only that he is entitled to a franchise and that there is continuous interference therewith by the defendant. It is not necessary that the plaintiff first establish his right at law. In some instances injunctions have been granted to parties having an exclusive right, to restrain another claiming the exclusive right from setting it up, the ground of the jurisdiction being the removal of a cloud upon the title to the franchise. It is sometimes held that an exclusive right conferred by statute must yield to the public use, upon just compensation being paid therefor. In cases where the defendant is authorized to take advantage of the eminent domain laws, the injunction should be limited so as to remain in force only until compensation is paid. Section 584. Same. Continued. It is not necessary, to entitle the owner to relief in equity, that the franchise should be an exclusive franchise in the sense that the grant of another similar franchise to be exercised and enjoyed at the same place would be void. The theory is that the defendant, who has no franchise, is acting in violation of law in operating without authority from the sovereign power. and that the owner of the franchise may complain of and restrain such illegal acts when they result in injury to his franchise, which, in the eye of the law, is property. As to the one who is invading his rights without legal sanction, the franchise is an exclusive franchise, although the owner of it might not be entitled to any protection as against the granting of a similar franchise to another.